Hello everybody, welcome back to our SSCMA classes. We are going to resume our law class. Yesterday's last topic was of audit committee under section comment below. So we are going to start today's topic, which is Vigil mechanism under section 177 rule 7. Okay, let's go for this now. So which company have to make Vigil mechanism? But before that, we should know why this Vigil mechanism is made in the company. Vigil mechanism shall provide adequate safeguard to prevent victimization of whom? Of employees and directors. To prevent victimization of employees and directors, this Vigil mechanism is made. Okay, some companies are bound to make this, and those are number first, listed company. Okay, wait a second, yes, let's go for it now. So listed company, okay, we know this. Okay, and what about the second criteria? Company who have accepted deposit from public. Okay, there are two conditions. Number first was the listed company, every listed company. Okay, second, the company who have accepted deposit from public. This is the second condition, first part, and second part says about the company who have borrowed money from bank, financial institution, and that borrowing amount is exceed 50 crore rupees. Okay, if the amount borrowed by bank and financial institution by company exceeds 50 crore rupees, in that case the company have to go for Vigil mechanism. Is it clear? So there were two conditions. First, every listed company have to go for this. Second, those company who have accepted deposit from public, and second, public institution and bank which exceed 50 crore. Very good. Let's go for the condition. What is law saying? Okay, so section 177 rule 7. Let's write out section 177 rule 7 of Vigil mechanism for directors and employees. Okay, establishment of Vigil mechanism by certain company. As what I mentioned earlier, listed company, exactly, the company who have accepted deposit from the public. Here there is no amount prescribed. Okay, no amount is prescribed, which means whatever the amount is accepted, they have accepted deposit from the public, they will go for this Vigil mechanism. That companies have to follow this part. Okay, now the company which have borrowed money from bank, yes, public financial institution, okay, which exceed of rupees 50 crore, those who have accepted deposit less than 50 crore, which means for example 20 crore, the company have borrowed money from bank or public financial institution which is of 20 crore rupees, will not have to go for Vigil mechanism. Okay, is it part clear? Yes. Requirement of Vigil mechanism now, to provide adequate, this is adequate safeguard. Okay, adequate safeguard so as to prevent victimization of employees, yes, and directors. Okay, in case the company is not required to constitute an audit committee, then the board of directors shall nominate director to play role of audit committee for the purpose of Vigil mechanism to other director, and employees report their concern to that particular. Yes. Okay, what are the disclosure which is to be done in this? Whatever the decision is made by this committee, they have to show in disclosure is to be made on their website, the company's website. Second, in the board report. Okay, punishment for the contravention is company shall punishable with fine not less than 1 lakh, which may be extended up to 5 lakh. This is the same punishment. Okay, the limit is same as the audit committee was having. Okay, and any officer of the company who is in default shall be punishable with imprisonment, may extend up to 1 year, or with fine which shall not be less than 25,000 but may be extended up to 1 lakh. Remember, okay, and imprisonment of 1 year. Okay, this is also same, any of them or both. Is it part clear? So to safeguard the To prevent the victimization of directors and employees, Vigil mechanism is to be followed by companies. Okay, so let's go for the next topic, which is Nomination and Remuneration Committee. Section is 178, Rule 6. Okay, Rule 6 was also of Audit Committee. Section 177, Rule 6. Okay, what about Vigil mechanism? Section 177, Rule 7. And again, Nomination and Remuneration Committee, which says about Section 178, Rule 6. Okay, so every listed company, again we are having the same criteria as the audit committee were having. Okay, so Nomination and Remuneration Committee have to be followed by every listed public company. Again, the public company were having paid up share capital of 10 crore or more, right? Turnover of 100 crore or more, right? Aggregate outstanding deposit debenture which exceed rupees 50 crore. Is this part clear? This is same criteria as audit committee. And one more, do you remember that section? You have to comment below. Okay, now what is the composition of, we have to compare the composition of audit committee and this Nomination and Remuneration Committee. Okay, in Nomination and Remuneration Committee, they should consist of 3 or more non-executive director. So let's compare it with audit committee. There should be at least 3 director, right? Okay, and in that case, audit committee independent director should be more than majority should of independent directors. Okay, now in this case, independent director should not be less than half of members of which is Nomination Remuneration Committee. Okay, so they are saying the independent director should not be less than half of members of NRC. Do you remember? This was the same criteria of that more than half of majority should be of independent director, and here they are saying that in NRC the independent director should not be less than, so which is saying we should be more than, right? Okay, now company's chairperson cannot be chairperson of NRC. Is this part clear? Yes, the company's chairperson cannot be appointed as chairperson of Nomination Remuneration Committee. Okay, chairperson of NRC can be executive director or non-executive director. Okay, hope so you know the meaning of non-executive director. I already explained this in the very first lecture of disqualification of directors. Okay, so let's go for what law is saying now. Section 178, Rule 6 of Nomination and Remuneration Committee. Mandatory constitution of Nomination and Remuneration Committee by certain company, which is again listed public company. Public company having paid up share capital of 10 crore or more, remember? Yes. Turnover of 100 crore or more? Yes. Having aggregate outstanding loan, deposit, debenture which exceeds rupees 50 crore. Is this clear? Yes, this is clear. However, this is the same condition written in audit committee, right? So, however, the following classes of unlisted public company shall not require to constitute the Nomination and Remuneration Committee, and those are joint venture, a wholly owned subsidiary, a dormant company. Is it clear? Yes. So, composition of Nomination and Remuneration Committee, they shall consist of 3 or more of non-executive directors. Okay, not less than 1/2 of member of Nomination and Remuneration Committee shall be independent. Okay, independent directors. Okay, the chairperson of the company shall not be a person nomination for Remuneration Committee. Okay, however, the chairperson of company may be appointed as member of Nomination and Remuneration Committee. Any director with executive or non-executive director may be appointed as chairperson of Nomination, and we already understand this, I think. Okay, now let's go for the functions of Nomination and Remuneration Committee under section 178, subsection 2, subsection 3 and subsection 4. Okay, let's go for it. They are saying the committee shall identify persons who are qualified to be directors in the company. This committee, which committee they are talking about, Nomination and Remuneration Committee, have to identify first those person, and they are going to prescribe the qualification which is to be the qualification for directors, okay, shall specify the manner and effective evaluation of performance of board, okay. They have to evaluate the performance of board and shall formulate the criteria for determining qualifications of director. Yes, this was already mentioned. Shall recommend a board policy related to remuneration for director, scheme and personal and key personal and other employees. Okay, this part is also cleared. Policies shall be placed on website of a company if any salient feature of the policy and changes in along with the website address of the policy should also disclose on the board report. So the main function of nomination remuneration committee is to, first of all, they have to formulate the criteria for determining the qualification of directors. Okay, they will specify the manner and effective evaluation of performance of board. Okay, second, they are going to decide the remuneration to be remuneration for directors. Okay, and if any other policy, every policy is to be placed on website, and if any salient feature of policy and changes is made in that policy, that should be placed on website along the address of policy shall also disclose in the board report. Okay, now what are the punishment? These punishment are as same as, yes, audit committee. So the company shall punishable with fine which may not be less than 1 lakh rupee, yes, but may be extend up to 5 lakh, yes. Every officer of company who is in default shall be punishable with imprisonment for may extend to 1 year, or fine not less than 25,000 and may be extended up to 1 lakh, or both. Is this part clear? Yes, this part is cleared. Okay, so let's go for the another section of stakeholder relationship committee. Section number 178, again rule 6. So we have rule 6 in 3 sections. The first was of audit committee, nomination remuneration committee, stakeholder and relationship committee. So we are going for stakeholder relationship committee. Okay, section 178. Section 178. So what is this? Why is this made? To resolve the grievance of security holder, to resolve the problems of security holders. Now which company have to constitute stakeholder relationship committee? Okay, those company who are having more than 1,000 either shareholder or debenture holder or deposit holder or any other security holder. Again, the SRC is going to be constituted only. Why the SRC is constituted? To resolve the grievance of stakeholders, security holders, and the company, those who are having more than 1,000 number of shareholder, debenture holder, security holder, deposit holder or any other holders. Okay, any other security holders. Okay, during financial year, in this case the company have to constitute this SRC, stakeholder relationship committee. Okay, now the chairperson can be in this case this chairperson shall be non-executive director. In previous section we read that chairperson could be non-executive director or executive director, right? What was that? Comment below. Okay, so in this case in SRC the chairperson shall only be executive director. Okay, now let's go for the law. Okay, establishment, section 178, rule 6, stakeholder relationship committee. Establishment of stakeholder relationship committee by certain company. Every company were having more than 1,000, either shareholder, debenture holder, deposits holder or any other security holder during any time of financial year. Again, more than 1,000 of, again, shareholder, debenture holder, deposit holder or any other security holders. Okay, during any time, at any time during financial year. Is this part clear? Yes. So composition of stakeholder relationship should be the chairperson who shall be non-executive director. I told you this, right? And shall have all other members as decided by board. Is this part clear? Yes. So, what are the functions of stakeholder relationship committee? The stakeholder relationship committee shall consider and resolve the grievance of security holders of the company, right? Note, if the chairperson of the stakeholder relationship committee or in his absence or any other member of such committee authorized by him in his behalf shall attend the general meeting of the company. Okay, this part was clear. So, let's resume these 4 sections along with audit committee. Okay, let's do it again. The revision is like audit committee section 177 rule 6, listed company, public company, paid up share capital 10 more, turnover 100 more, and again aggregate outstanding loan of 50 and more. Okay, and what was the composition? Consists minimum of 3 director, majority should be of independent director, should be able to understand and have knowledge, adequate knowledge and qualification to read and understand the financial statement of the company. Is it okay? Yes. 177 rule 6, 177 rule 6 audit committee. Now let's go for Vigil mechanism 177 rule 7. Who have to go for and one more thing, the punishment are same in them. Okay. So let's go for again Vigil mechanism, listed company who have accepted deposit from public, no amount criteria is specified here. Okay, and the company who have borrowed money from deposits, borrowed money from bank and financial institution which exceed 50 crore. Is it clear? Yes. 178 rule 6. Okay, nomination and remuneration committee are also having the same criteria. So I'm not going to say it again. I am going for composition of NRC which consist of 3 or more non-executive directors. Should minimum consist of 3 or more. Okay, non-executive director. In this case, the chairperson can be executive director or non-executive director. Yes, independent director should not be less than 1/2 of the member of NRC. Is it clear? Chairperson of company cannot be appointed as chairperson of NRC. Yes. Now last was of stakeholder relationship committee 178 rule 6. Okay, those company were having more than 1000 shareholder, debenture holder, deposit holder or any other security holders. Okay, at any time during financial year. Okay, then in that case the company have to go for this, and the chairperson shall be only non-executive director in this case. Okay, so let's go for our next topic, which is power of board, section 179 rule 8. Section 179 rule 8. Okay, I'll tell you, board are having power in them. Okay, the directors are having power with them, but in some certain case they cannot act. Okay, they have to take the permission by members. Okay, so let's go and read out what are they. First of all, what are the powers which they are having in their hand, and what are the powers which they are not having in their hand. Okay, section 179 has given by power to board of directors by allowing them to access all the power of company except those power which are reserved for shareholder to be exercised at general meeting. This is what I said. Okay, some powers are not in their hand which are reserved to shareholder, and by exercising at general meeting they have to take the permission from members. Okay, power exercised by passing, just a second. Okay, power exercised by passing resolution at board meeting only. As per section 179 subsection 3, the board shall exercise the following power only by means of resolution passed at board meeting. Okay, for example, in this case what the law is saying, the power is exercised in hand of director only by passing a resolution at board meeting, only by passing a resolution at board meeting. And what are the powers in the hand of directors? Okay, so the power to make calls on share. For that they have to first of all pass the resolution in board meeting, and they are the power to make call on share, to authorize buyback of securities under section 68, buyback of securities under section 68. And one more thing, buyback can only be authorized if it is prescribed in the articles of the company and special resolution is passed, okay, in the general meeting. In this case, the buyback can only be authorized if it is mentioned in the article of the company. Second, special resolution is passed in the general meeting. Is it clear? Yes. The company can buy back its own securities without SR. Earlier we were talking about for buyback, it should be mentioned in article of the company. Okay. Along with that, the special resolution is to be passed in general meeting. But now we are saying there is one exception for this, which says the company can buy back its own securities without passing SR if the 10% of it is up to, the buyback is up to 10% of aggregate paid up equity shareholder and free reserve. In that case, the company need not to pass special resolution. What is that? First condition of exception says that the company can buy back its own security if without passing special resolution, if the buyback shares is up to 10% of aggregate value of paid up share equity capital plus free reserve. Okay. And second, if authorized by resolution passed in board meeting. If it is authorized by resolution which is passed in board meeting, in that case also the board director, the BOD need not to take the special resolution. Okay. Okay. Next, to issue security including debenture, whether in India or outside India. They can issue securities even including the debentures. They can borrow money, invest the fund of the company, to grant loan or give guarantee to provide security, but in these case the power is of board is, they have to take the permission of whom? They have to exercise the power are exercised by passing the resolution of board meeting only. Then only they can go for borrow money, invest the fund of company and grant loan or give guarantee or to provide security in respect of loans. Okay. To approve the financial statement and board report, to diversify the business of the company, to approve amalgamate, merger, reconstruction of the company, to take over of a company or acquire a controlling and substantial stake in the another company or any other material which may be prescribed. Okay. So let's read again. The board have the power to exercise by passing a resolution in board meeting. They can buy, they can make call on shares, authorized to make buyback. They can also purchase their own shares. Okay. For that they have to go for the, they have to check whether that condition is written in the article, if it is authorized in the article, and plus special resolution is to be made and passed in general meeting. Okay. But there is some one exception, if the buyback of share is up to 10% of aggregate or paid up equity share capital plus free reserve. In that case, no need of passing special resolution in general meeting. And second, if authorized by, if the buyback of share is authorized by resolution in board meeting. Is this clear? Yes. And to issue security, of course, to borrow money, invest and grant loan, to approve financial statement in case of diversify the business of the company, approve amalgamate, merger, demerger, reconstruction of the company, to take over the company, acquire substantial stake in another company and any other matter. Okay. For this, the board have to pass the resolution at board meeting. The directors have to pass the resolution at the board meeting. Okay. Now, yes, there are few more points which we have to read now. As per Rule 8 of the company, okay, Rule 2014, the following power shall be exercised by board by passing a resolution in board meeting only: power to make political contribution, power to appoint or remove key managerial person, power to appoint internal auditor and secretarial auditor. Is it clear? Okay, now we are going for the restriction on board of power of board. There are some restriction on power of board under section 180. Okay, for that they have to take the permission. Earlier what I told that in 179 we read that they can exercise their power by passing board meeting. Right, in board meeting they are going to be directors, right, but they, in some specified cases, the directors, the board of directors have to take the permission of members of the company. Now we are going to read that the restriction on power of board under section 170. BOD shall exercise BOD shall exercise the following power only with the consent of company by passing SR. Okay. Number first, sell, lease, otherwise disposal or any other substantial way of one or more undertaking of the company. They are saying that they can either go for selling, exchange of or selling, exchange or discharge, disposal, discharge, disposal of undertaking, of undertaking. They are saying about they can go for, they can't go for here, okay, for selling, okay, exchange, disposal, discharge of undertaking. Okay, now the things come, what is this undertaking? Now we have to understand first of all what is undertaking. Undertaking is the investment of the company. Okay, if the investment of the company is more than 20% of its net worth, okay, I'm saying it again, investment of the company is more than 20% of its net worth as per audited balance sheet and audited balance sheet of previous financial year. If the investment of the company is more than 20% of its net worth, okay, as per audited balance sheet of financial year, okay, preceding financial year. Or second, this was the first condition of undertaking. Second, undertaking generate 20% of the total income of the company. For example, total, they are talking about the 100%, no, they are talking about the 20%. If the undertaking generate 20% of the total income of the company, okay, in that case, that would be again undertaking, okay, during previous year, which generate 20% of the total income of the company. Okay, either investment of the company is more than 20% of its net worth in preceding financial year. In that case, that is going to be undertaking. Now let's go for again what law is saying. Let's read it again. Sell, lease, disposal, removal or any other way, okay, substantially the way of one or more undertaking the company. So in this case, this is the first point where section 180 subsection 1 clause A, 180 subsection clause A, 181A, 181A, okay. So in this case, the board is restricted. The board have to take permission, okay, by whom? By members, by passing special resolution, okay. So the board have no power to sell, to lease or to exchange, to dispose, to whatever they if there is any other thing, okay. So whatever is that, they cannot go for this part of undertaking of the company, okay. Now the second thing says that the under section 180 subsection 1 clause B says the invest the compensation received, whatever the compensation is received by the company as a result of merger and amalgamation. The company cannot invest the money which is the result of merger or amalgamation without taking permission of members, okay. So let's go for it. Consent of member is not required. There is again some exception, okay. Earlier what I said that the company, the BOD, okay, the BOD cannot invest the compensation received by way of merger or acquisition, okay. Now there is one exception to this, which is saying that the consent of member is not required, if the compensation received by the company is invested in trust securities. Is it clear? If the compensation received by way of merger and acquisition is let's go for it, invested in trust securities under section 20 of Indian Trust Act. If the amount is fully amount is invested in trust securities of under section 20 of Indian Trust Act, in that case the BOD have not to take the permission from members. Is it clear? So first point was of 180 subsection 1 clause A say that they cannot go for sell, lease, disposal and so of undertaking of the company. Second, they cannot go for, the BOD cannot invest the compensation received by the way of merger acquisition But what was the exception? Exception was there, right? The exception says that they can go for it, but it should be invested. The fully amount should be invested in trust securities under section 20 of Indian Trust Act. Is it clear? Yes. Let's go for the third part, third point of restrictions, okay, which says the borrow money. If they borrow money, they are talking about the borrow money, the company have to borrow money from outsiders sometimes, right? If money borrowed, money already borrowed together with money to be borrowed will exceed the aggregate of paid up share capital, free reserve, security amount, in that case the company have to go for this special resolution. Okay, let's break out what they are saying. If the paid up share capital, if the free reserve, if the security premium account exceed the borrowing amount, again if the paid up share capital, if the free reserve, if the security premium account exceed the borrowing amount of the company, okay, in that case the company have to pass special resolution for further borrowing amount. Okay, so there are something which is not to be included in borrowing, that is temporary loan. Now the things come that what is this temporary loan? Temporary loan do not include the loan raised for financial capital expenditure. Is it clear? The temporary loan do not include the loan which is raised for financial capital expenditure, which means they are repayable on demand, okay, or repayable within 6 months of date of issue of loan. Okay, so in this case temporary loan is not going to be added in loan amount, borrowing amount. Okay, the last point of this section says the remit or give time for repayment of debt due by directors. The board of directors have no right to grant time or to extend time for the directors of the company. For example, sometime the director take loan from the company. Okay, so the board of director are not having any time, having any power to extend the time limit of that directors. Okay, so the provision cannot apply for private. This is one more exception of this case, that this provision do not apply for private company. Okay, if they have not committed default in filing financial statement under 137 and annual return under section 92. Okay, with whom? With the registrar. Is it clear? So again the BOD have no time to remit or to grant, to give, to extend the time limit of repayment of any debt due by the director of the company. Section 180 subsection 1 and clause D says about this, but the exception was of this is not going to apply in case of private company, but when they have not made any default in filing financial statement under section, comment below, and annual return, comment below section. Okay, with whom? With registrar. With whom? With registrar. Is it clear? So let's rewind this section again, guys. There are some restriction on power of board under section 180. 180 is 1A, 181A, which means subsection and clause. Okay, so 181A says about the sale, lease, disposal of undertaking of the company. Okay, second about they cannot invest, the BOD cannot invest the compensation received in way of merger, amalgamation. Okay, but there is some exception. 181B says that there is one exception. They can invest the fully amount in trust securities without taking the permission from the members of the company by passing this special resolution. Okay, third of the borrowing amount should not exceed paid up share capital, free reserve, security premium account. Okay, if it is exceeding, then what should be the procedure? Then the special resolution is to be passed. Okay, temporary loan is not going to be added in borrowing. Temporary loan are those which are repayable on demand or which are to be repayable within 6 months of date of loan. Is it clear? And the last point was of 180 subsection 180 1D remittance. The BOD have no power to give, to grant, to remit or to extend the time limit of repayment of debt due by director. But exception again, private company, again default, not making any default in filing financial statement and annual return. Yes, with whom? With registrar. So that's it, guys. Today's topic was up to this. We'll meet again. Up to then, you go and do revision and solve question and have some writing practice. That's it.